Who should not be a trustee? When it comes to selecting a trustee, it is essential to consider who should not take on this important role. A trustee is responsible for managing a trust and acting in the best interests of the beneficiaries. However, not everyone is suited for this responsibility. First, individuals with conflicts of interest should be avoided. In many areas, the law disqualifies certain people from being trustees, especially those who drafted the trust or are closely related to the drafter. This helps to prevent any potential self-dealing or undue influence. For example, if a beneficiary stands to gain significantly from the trust, they may not be the best choice as a trustee. Next, financial stability and competence are vital. A trustee needs to manage trust assets wisely. If someone has a history of poor financial decisions or struggles with managing money, they might not be the right fit. A trustee should be able to handle investments and distributions effectively. Another key factor is willingness and availability. If a person does not want to be a trustee or cannot commit the necessary time, they should not take on the role. Trustees must act impartially and keep detailed records while filing required reports. If someone is unable to fulfill these duties, it can lead to issues down the line. Additionally, individuals with a history of hostility or conflict should be excluded. When there are co-trustees involved, ongoing disagreements can hinder effective trust management. A trustee should be someone who can work well with others and maintain a cooperative spirit. It is also important to consider those who may abuse their position. A trustee has a fiduciary duty to act solely in the best interests of the beneficiaries. If someone has a history of dishonesty or fraud, they should not be trusted with this responsibility. Lastly, professionals or family members who may exert undue influence should be approached with caution. Even if they are related to the person who created the trust, their potential for bias can be a concern. In the context of estate planning, life changes often requiring updates to trustee appointments. If a trustee becomes incapacitated or unwilling to serve, it is essential to review the trust document. In some cases, changing a trustee may require court approval, especially if the trust is irrevocable. To ensure effective trust management, avoid naming beneficiaries as sole trustees if they may have conflicts. Consider appointing a neutral third party, such as a professional fiduciary or trust company, particularly in complicated family situations. Regularly reviewing trustee appointments after significant life events can help maintain the right fit for the role. If a trustee is not performing adequately or is disqualified, beneficiaries can petition the court for their removal. Selecting the right trustee is vital for protecting the interests of beneficiaries and ensuring smooth trust administration.